Hello friends, Namaskar. In today's class, I will discuss the protocol of appeal from section 420 of BNSS. In the previous class, that is class number 1, in which I have discussed the protocol from section 416 to section 419 of BNSS. Basically, section 420 of BNSS incorporates the provisions of appeal against conviction by High Court in certain cases. It says that where the High Court on appeal reverse the order of acquittal and convicts the accused and sentence him accordingly, means with death or imprisonment for life or imprisonment for a term which may extend to 10 years or more, he may appeal to Honorable Supreme Court. So basically, the said protocol is concerning with the general protocol. The said section corresponds to section 379 of CrPC 1973. Now we are coming on section 421 of BNSS. It says the special right of appeal in certain cases. It says notwithstanding anything in this chapter, when more persons than one are convicted in one trial and on appealable judgment or order has been passed in respect of any of such person, all or any of the person convicted at such trial shall have a right to appeal. So basically, if the appeal is filed by any of them, in that scenario, on rule of parity, the other accused person could also file an appeal. So basically, the said section merely set the general principle to make an appeal. As far as section 422 of BNSS is concerned, basically it laid down the process of hearing of appeal by court of session. Subsection 1 simply says, subject to the provision of subsection 2, an appeal to court of session or session judge shall be heard by court of session or by additional session judge. But there is a proviso that says that an appeal against conviction on a trial held by a magistrate of second class may be heard and may be disposed of by CJM. So the key point to be noted is that the appeal against conviction and conviction, if passed by magistrate of first class, would lie to court of session, and court of session may transfer the appeal for hearing to additional session judge. But in case the magistrate is of second class, in that scenario, appeal may be heard and may be disposed of by CJM. As far as subsection 2 is concerned, it says the additional session judge or CJM shall hear the appeal only when it is allocated to them by general or special order passed regarding the same, and apart from that, the order may be passed by Honorable High Court concerning the hearing. The said section corresponds to section 381 of CrPC 1973. Section 423 of BNSS is concerned with petition of appeal. Basically, it is concerned as memorandum of appeal. It says that every appeal shall be made in the form of petition in writing presented by the appellant or his advocate. Every such petition shall be accompanied by the copy of judgment or order appeal against. To be noted that the copy must be certified. If the copy is not certified or it is photocopy of certified copy, in that scenario, there will be a defect as per the protocol of section 423 of BNSS. Now we are coming on section 424 of BNSS that says process when the appellant is in jail. If the appellant is in jail, he may present the petition of appeal and the copies accompanying the same to the officer in charge of the jail, who shall thereupon forward such petition and copies to the proper appellant court. But in the practical sense, it is having no value, because whenever you are convicted, even though you are in jail, the concerned relative of you have to engage a lawyer to present the appeal before the Honorable High Court or before the court of session. The said section corresponds to section 383 of CrPC. Now we are coming on section 425 of BNSS. Basically, it laid down the summary dismissal of appeal. It says that if upon examination of the petition of appeal and copy of judgment received under section 423 or section 424, the appellant court considers that there is no sufficient ground for interference, it may dismiss the appeal in summary manner. It is called in limine dismissal. There is a proviso that says no appeal presented under section 423 shall be dismissed unless the appellant or his advocate has a reasonable opportunity of being heard in support of same. So basically, it emphasizes that before passing such order, the concerned advocate or the concerned party is required to be heard. If they are not heard, in that scenario, there will be a violation of section 4 to 5, subsection 1, subclause A. In that scenario, on the ground of breach, the order could be asserted before the Court of Appeal or Court of Revision accordingly. Subclause number B says that no appeal presented under section 4 to 4 shall be dismissed except after giving the appellant a reasonable opportunity of being heard in support of same. But if the appellant court considered that the appeal is frivolous or that the production of accused in custody before the court would involve such inconvenience as would be disproportionate in circumstances of the case, in that scenario, the concerned appellant court may refuse to give the reasonable opportunity of being heard, but in practical sense, I want to clarify that in every appeal, the concerned party or the concerned advocate is required to be heard. If no opportunity is given, then on the point of infringement of natural justice principle, the concerned appellant court may remand back the appeal for the proper adjudication. As far as clause number C is concerned, it says no appeal presented under section 4 to 4 shall be dismissed in summary manner until the period allowed for preferring such appeal has expired. So basically it is having of no practical use, it is in general way had been incorporated. But the key point to be noted is that while disposing the appeal, the concerned court is required to hear both the party or the advocate. In case the concerned court passed the order without hearing the concerned party or his advocate, in that scenario there will be the infringement of the principle of natural justice. On that count, the concerned order could be asserted. Subsection 2 says that before dismissing an appeal under this section, the court may call the record of the case. Subsection 3 says that where the appellant court dismissing an appeal under this section is the court of session or the CGM, it shall record the reasons for doing the same. So basically recording of reasons is also going on while dismissing the appeal. And apart from that, subsection 4 says that where an appeal presented under section 4 to 4 has been dismissed in summary manner and the appellant court finds that another petition of appeal duly presented under section 4 to 3 on behalf of same appellant has not been considered, the court may, notwithstanding anything contained in section 434, if satisfied that it is sine qua non in the interest of justice to do so, hear and dispose of such appeal in accordance with law. And the said section is also having no practical application. So simply we could say that as far as section 4 to 5 of BNSS is concerned, the court may dispose of the appeal in summary manner. But the key point is that before doing the same, the concerned court is duty bound to hear the party or the advocate. If the opportunity is not given, in that scenario there will be infringement of principle of natural justice. In that scenario, the order would be illegal and the concerned order could be asserted on that point alone. So I think that I am totally able to cause all of you to understand the protocol of section 420, 421, 422, 423, 424, 425 of BNSS. In class number 3, I will discuss from section 4 to 6 of BNSS and onwards. See you in the next class. Till then, Jai Hind, Jai Bharat.